A contract regulates risk distribution. When two parties enter into a contract, what they are really doing is distributing the risks associated with that sales transaction between themselves. And that's part of the negotiation process, in which you want to take on as little risk as possible, and therefore you want to shift the burden of risk to the other party as much as possible. And on the other side, they have the same desire to minimize risk on their own behalf, but to maximize the risks on your behalf. So in any transaction, there's going to be a level of risk, and you, as a business person, want to manage the level of risk as much as you can. And you do that through the use of a contract. That's what contracts are for. They are to distribute risks involved in the sales transaction, those risks that we talked about. Now, parties can contract pretty much to any risk, even those risks that may seem absurd or improbable, even those risks wherein the parties have no control over the matter. Nevertheless, the parties can contract to those risks. If I have an unnatural fear of my goods being struck by an asteroid, I can contract to that. I can provide that in the contract that if the goods are struck by an asteroid, I get paid anyway. You know, that's absurd. And the other side will say, well, the odds of those goods being destroyed by an asteroid are so ridiculously small that it doesn't matter. We'll take on that risk. So parties can contract with a risk even if it's not something that ordinarily arises in that particular transaction. Parties can also contract for termination of the contract without performance, meaning the parties can build in a way of terminating the contract without breaking the contract, what we call breaching the contract. A breach of a contract is a failure to perform. And ordinarily, a breach of a contract, a failure to perform, leads to the award of damages. But in our contract, if I am afraid that I'm not going to be able to perform, either pay for the goods or ship the goods, we can contract to that in our contract for termination without performance. And then when I fail to ship or I fail to pay, it's excused because I am meeting the terms of the contract. Now, a contracting system must do certain things. And the first thing a contracting system must do is to provide the requirements of a valid contract. Now, contract is formed in any transaction in which one or both parties make a legally enforceable promise. Because that's what a contract is. A contract is essentially an enforceable promise. Now, we do not enforce every promise. Our legal system, our contracting system, says that some kinds of promises are enforceable. Others are not. And when we talk about enforceable, what we're really talking about is the parties to an agreement. If one of the parties fails to live up to the agreement, the non-breaching party, sometimes called the innocent party, but essentially the party that did not breach, has the right to go to the state, the court system, and demand that the other party comply with the agreement. That's what makes contracts unique, because with a contract, with a legally enforceable contract, either party can call on the power of the state to come in and force the other party to perform. So a contracting system must establish what kinds of promises that society will enforce, because society will not enforce every promise, which you probably learned in 3213. So that's the first thing a contracting system does. It provides the requirements of a valid contract. What is a valid contract? And we'll be talking about that in terms of the CISG, which is the contracting system that we study in the second half of the course. Now, the second thing a contracting system must do is it must provide guidance for performance. You know, it's easy to say performance when, I go to buy a bag of chips at the convenience store. Performance consists of me taking the money out of my wallet, handing it to the cashier, and the cashier handing me the chips. And performance is pretty clear cut. But in a lot of transactions, in many transactions, exactly when and how performance takes place, it can be difficult to figure out. So a contracting system must provide for rules regarding performance of a contract. And the reason being that there must be a point at which a party can say, I performed under the agreement. And so the level of performance is provided by the contracting system. Now, the parties to a contract need to know with certainty when their obligations under the contract are complete. When does the contract end? Because a contract involves the taking on of mutual obligations. One party owes the other party an obligation. When is that contract over? The contracting system will tell us that. And a breach, again, I'm going to use that word a lot in this part of the course. A breach simply means a failure to keep your promise, a failure to do whatever it was that we were obligated to do in the contract itself. Now, the third thing that a contracting system must do, and make sure you know these three things, it's easy to ask on a test and it'll doubtlessly come up at some point. The third thing a contracting system must do is provide remedies for the failure to perform. The contracting has to provide a remedy for the breach of a promise. Remedy is something that we really don't think about when we think about the law. But in fact, every law has two aspects. There is a right, and then there is a remedy associated with that right. There is an obligation, and then there is a remedy if the obligation is not met. And the reason it's important is that these remedies give the law meaning. That if we execute a contract and our contracting system doesn't provide for a remedy in the event of a failure to perform, then the contract itself is meaningless. A right without a remedy is essentially no right at all. So one of the important functions of a contracting system is to provide a remedy for the breach of a promise, because that remedy gives to the contract meaning. Now, those remedies can take different forms depending on the nature of the contract, and again, the contracting system will specify what those possible forms of remedy are. And again, we'll cover that when we get to the CISG.